I thought that I would start by just reminding you how important the skill of advocacy is in a common law court. You all know perfectly well that in the civilian tradition, most things are done in writing, cases pleaded in writing, submissions are made in writing, the judgment is handed down in writing. There's very little opportunity for oral advocacy. And there's almost no opportunity for cross-examination of witnesses. Most of the experts tend to be court experts. So the common law tradition is very, very different. And the common law practitioner has got to get used to advocacy, i.e. persuasion, both in writing and orally. And you'll be surprised to learn that judges greatly favour oral advocacy. And that is even so in many of the civilian courts of the world. If you go to the European Court of Justice, where out of the 27 countries there are only 3, or perhaps only 2, which are common law jurisdictions, all the judges of the European Court can't wait to hear from a British or Irish barrister, rather than some stumbling Frenchman or German, who as soon as somebody asks him a question, falls over. And the reason why oral advocacy is so attractive to judges is because it allows them not merely to move things on when necessary. All right, I've got that point, move on to the next point. But perhaps even more importantly, allows the judge to test his own impressions of the points. He can actually ask a question and say, what do you say about this, or what do you say about that? But just one word of warning. A friend of mine in London defines the art of advocacy as the art of casting artificial pearls in front of real swine. Now let's just very briefly, if I may, look at a small typical case from the perception of the judge, i.e. the man who's doing the listening and the reading, as opposed to the man who's doing, or woman who's doing the speaking or the writing. So what do you start with? Well, you start, of course, in the English tradition with a skeleton argument. I'm sure you will hear much about skeleton arguments in a moment. But before you write your skeleton, you've got to decide what you want the judge to read before the case starts. Can I ask you to think pretty carefully as to what you ask him to read, rather than just say, read the papers? In particular, can I suggest that you don't ask him to read the pleadings? My own experience is that is a very unrewarding experience. Pleadings are for the benefit of the parties, so they know what case they're having to answer or respond to. Judges don't want the pleadings, they simply want to know what the issues are. So don't ask them to read the pleadings. Certainly suggest they read the main statements, but not the exhibits. Certainly ask them to read the experts' joint reports, but not the exhibits. But don't ask them to read the documents. Try and get together a bundle of core documents which you can use during the hearing itself. So that's reading. Next thing, skeletons. These are rather crucial documents. They set the tone for a party's case. And I must admit, judges necessarily, at the end of reading the skeletons, will start to form an opinion about the issues of the case. And therefore, your skeleton, if it's persuasive, will be extremely valuable. Make sure the skeleton addresses the issues rather than describes the history of the case over the previous 10 years. And make sure that it's not too long. I would suggest that something like a maximum of 20 pages is all you really need if you focus on it carefully. Then you have the oral witnesses. Well, no, before that you have the oral opening. This is not as valuable as some people think. The judge has read the skeleton, he's begun to form a view about the issues. It's very unlikely that you can say and introduce in your opening something that you haven't actually discussed in your skeleton. So, an opening can be pretty brief. The main point you want to do if you're opening for the claimant is just to deal briefly with what seem to be the better points the other side are making, and then sit down and the trial can go on. Don't regurgitate the skeleton argument. Don't go back to the beginning and describe the history of the case. Always focus on the issues, but focus on the points that the other side are making. Then you have witnesses. Now, cross-examination, of course, is an art, but I think it's very important that you understand what the benefits can be of cross-examination. If the judge is faced with a dispute of fact, he almost inevitably will seek to resolve it, not by looking at a witness and forming a view of what impression they leave, whether they look shifty or whether they look reliable. On the whole, that's a thoroughly unsatisfactory and dangerous way of assessing evidence, because the very shifty, nervous witness may be entirely truthful, and the thoroughly over-the-top witness may be entirely untruthful. What judges are listening for, and remember this when you're cross-examining, is a disparity between what the witness is saying and what the documents say, and a disparity between what the witness is saying and what I would call the probabilities of life. So when you're cross-examining, focus on the documents if they are inconsistent with anything the witness has been saying in his statement. And equally, focus on the probabilities if they seem to be wholly inconsistent with what the witness has been seeking to say. Then you have experts. Well, there may not be in every case. My experience is, on the whole, experts, if they've met, will agree almost all the controversial issues. And so it's likely you're going to be able to say to the judge, everything is agreed on the expert side except X and Y. So focus on X and Y and only on X and Y. And put the points you have and leave it at that. And then lastly, you have a final speech. Again, keep it short. Keep it by reference to the issues in the case. This is an opportunity for the judge to ask questions, try and answer them. More importantly, try and listen to what the question was, and try and answer the question as was asked. Because the judge may give the impression, by the way he's putting his questions, that he's against you. Don't assume that. The judge may be simply testing your proposition by advancing the contrary. It's in order to give himself support for the conclusion that he's moving towards. So don't be frightened by the judge saying, "No, come on, that can't be right. What about X and Y?" He may well be saying, "Well, look, just help me with these two little difficulties, and I can probably find my way to find in your favour on that particular topic." So don't be frightened by the judge appearing to be having already made his mind up against you. Almost certainly he has not. That's about it, I think. Those are my suggestions from the other end.